What's up, everybody? I gotta start my recording. Give me a second. Hey, everybody, it's Christopher Small. We gotta wait a second. Hey, everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk about estate planning for non-married couples. Before I get to that, though, I want to remind you if you have anything, any questions or need any help related to anything, estate planning or probate related. Use the word related a lot there. What a great start to this video. You can set up a time to talk with us over the phone for free by going to cmslawfirm.com. Okay, had two conversations today with potential clients that were not married couples, and I wanted to take a second to talk about this. I've talked about it before, but it's been a while, and it's really, really important to know this kind of stuff because it can really sort of bite you in the butt down the road. So, estate planning for non-married couples is in some ways very similar to married couples, but in some ways even more important than for married couples, because when you're married, you get you have a few sort of advantages from an estate planning perspective that you just don't have if you are not married. First things first is that many or most non-married couples keep at least one, sometimes a couple of separate bank accounts. And this is really important because if something happens to one of the two people, the other person is not going to be able to access that other bank account and use it unless they have a power of attorney. So that's the first part of the estate plan for non-married couples, is to have a current power of attorney. Now, I will say this: if you are married and you have separate accounts, you too cannot get access to that separate account if you do not have a power of attorney for your spouse. Okay? The people on the account get access, nobody else does unless you have a power of attorney. Number two, medical power of attorney. This is where there's a little bit of a difference. If you are not married and you do not have a medical power of attorney and something happens to your partner, you go to the hospital to try to find out what's happening and what's their status, you are going to learn very quickly that they are not giving you any information. Zero. Okay? If you are a spouse, there are some exceptions to the rule to not having a medical power of attorney that you can sort of overcome that over time. You can, I think, probably convince them to give you that information. But if you are not a spouse and you do not have a medical power of attorney, you are going to be SOL. I won't tell you what the S stands for, but the other two is out of luck. SOOL. This video is just getting even better. Better and better over time. Okay, so that's the second important thing. Healthcare directive is the same for both. Will is going to be different for both. Also, disposition instructions. Disposition instructions, like burial instructions, if you are not married, they're actually critically important if you want to be able to have control over the remains of your partner if something happens to you. This is important because often the family doesn't know what to do or has different ideas of what to do with your partner's remains, and the disposition instructions give authority to the person that you choose to be able to take care of you, okay? And this is often going to be your partner. So that's important. Last but not least is the will. If you are not married and your partner dies, your partner is getting, and you have no will, your partner is getting nothing. Zip, zilch, zero, nada. Unless, caveat, you have listed them as the beneficiary on your accounts. In that case, they will get something, whatever you have listed them on as the beneficiary. But any other accounts that you did not, they will get nothing. It will go to their family. Okay? So, will is important because with the will, you can say, I want everything to go to my partner. That way, if you've left anything out from your beneficiary designations, or you just didn't do beneficiary designations, then your partner will be taken care of. Okay? So those are the things that are important when it comes to estate planning and non-married couples. Hopefully that makes sense. I know I just really crushed this video today from a performance perspective. I'm pretty proud of that. But in any event, as always, if you have questions or comments about this or anything else, please let me know. If you like this video, if anywhere you can subscribe, you don't want to miss anything, hit those buttons, okay? Let me know that you're here, that you're enjoying this stuff. It makes me feel good, okay? And if you have questions or related to probate or estate planning and you want to talk with us over the phone for free, you can do so by going to CMS cmslawfirm.com. All right, that is it, everybody. I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.